You put it on pause. Ross, there's so many different topics I got in my brain, but on this particular one, the reason I asked this particular topic was because somebody was asking me about it. And it was, they had a felony, and we were talking expungement, and then somebody said something about their rights lost, and I go, I know you can lose some rights, so I thought, why not talk about this? Because I'm sure there's a lot of people out there in that particular condition where they have a misdemeanor conviction, a felony conviction, and when you have that, you lose certain rights, and it can be very difficult for somebody once they realize, I made a stupid mistake in my life, and it's causing long-term aftershock.
Okay, so the reason you get a lot of these questions is because, obviously, for the license to carry provisions, you can't have certain convictions within time periods. Also, DWI is going to hurt you. Have a finding of a chemically dependent person, right? If you've had 2 DWIs in the last convictions in the last 10 years. But that code section 411, it's kind of, I guess, I don't know if it's ironic or coincidental or what. I don't know why the legislature put so many different kinds of topics within chapter 411 of the government code, but the license to carry provision and the petition for non-disclosure means to get your record sealed is actually falls under the same chapter. Okay, chapter 411, and so you can stay within that parameters of that chapter when you're looking at your license to carry, also at your conviction issues as far as getting them sealed, because the license to carry provisions state that a conviction means basically an adjudication of guilt, whether that's deferred adjudication or whether it's probation or whether your probation's been subsequently discharged and you've been dismissed. But it says in there the term does not include an adjudication of guilt or an order of deferred adjudication that has been subsequently expunged, pardoned under the authority of a state or federal official, or otherwise vacated, set aside, annulled, invalidated, voided, or sealed under any state or federal law.
Okay, I got all the beginning parts of it, but you said if for some reason a felony is sealed, then you're still okay?
That's what the provisions of the government code say. They say a conviction, does not include, an order of deferred adjudication that has been subsequently sealed under any state or federal law.
What would be an example if somebody gets convicted of a felony and then it gets put in a sealed envelope, wrapped up, put on a file?
Okay, so let's talk about the benefits of, and I want to start with that because it's a gun rights show, and I get questions, calls all the time. I don't particularly like doing these kinds of cases. I refer a lot of these now, but I did a lot of these in the beginning of my practice, and I still do a couple. I still do some that are for clients that I know or for other past clients, or maybe a case that's still pending that I'm working on. And so, these change all the time, and we're not going to get into very specifics because the statutes for expunction, the statutes to seal, the statutes for restoration of rights, pardon, even when you're getting into juvenile aspects, like is there a juvenile conviction, is a juvenile suspension, something of that effect. There's all different kinds of rules and codes for every single one of those. And then you've got offense specific. There's some offenses that are covered. So generally speaking, what's the difference in a non-disclosure, a seal, when you're asking the court for non-disclosure means they cannot disclose, so it's a sealing order, versus an expunction.
We say sealing, not sealing, roof sealing. We're saying sealing, it's secured, it's wrapped
sealed,
up.
To seal something,
Sealed,
yes. Okay. So I'll just read you what the code says, okay? And for an application for an expunction, okay, is going to say that the release, maintenance, dissemination, or use of expunged records or files for any purpose is prohibited. It says, except as provided in the following subsection, the person arrested may deny the occurrence of the arrest and the existence of the expunction order.
Okay, this is new to me. I'm learning.
I can say I didn't get arrested. I can say there's an application that says, "Have you ever been arrested for an offense?" No.
That's if it's sealed.
That's if it's expunged.
Expunged. Okay.
So for an expunction, if it's expunged, those records cannot be released. They cannot be maintained. They cannot be disseminated. They
never
cannot
existed.
be used. It never existed. It never existed. So I never got arrested. Somebody asked me that. The only exception to that rule is to say that you never got arrested is this. Number 3, it says, the person arrested or other person when questioned under oath in a criminal proceeding about an arrest for which records have been expunged may state only that the matter has been expunged. That's the only exception.
Why would they do that?
So you may state only. You may state only that the matter has been expunged.
I think if I had something on my record and I was blessed enough to be expunged, I'd say, okay, I'll deal with that one. All right. Sounds great.
Well, it says we're back on.
Back
so,
on.
okay, good. So,
hi, everybody. We had technical difficulties. We are back. And if you want to hear the first part of this, we'll probably be reposting the whole show on my website, aaronsgunshop.com, later today or probably tomorrow. And always check out our podcast from previous shows. So we got Attorney Extraordinary Benton Ross Watson. We're talking about expungements, misdemeanors, felonies. Y'all need to listen because I know you know somebody, and this is some good stuff.
Well, really brief recap. If you're trying to get a license to carry, it says you can't have certain convictions. The license to carry provisions say that a conviction is a deferred adjudication unless, right, it's been sealed. Okay, and so that's where we started off, and then we went into what is the difference between an expunction, right, to get your records expunged versus getting your records sealed. What is the benefit to those things? And basically the benefit to an expunction is you can deny the fact of the arrest. You can deny that the thing ever even happened. And nobody's allowed to even contain or use or release or anything regarding records of the arrest, the underlying magistrate orders, or the court records. All that stuff, right, is off limits to everybody. And it's like it never, like you said, never existed, with the one exception being if you're questioned under oath about the arrest in a criminal proceeding, you may only state, you can't say yes or no. And it says, I think it's funny, it doesn't say civil proceeding. It says a criminal proceeding. If you're questioned under oath, right, you may only state that the matter in question has been expunged. Okay, and so that's the only exception. Other than that, you can deny that the thing ever existed. So then what's the difference in the expunction and the sealing order, the petition or order for non-disclosure?
That's a very good question.
Okay, so if you get an order for non-disclosure, I'll just read the statute to you. Okay, it says a person whose criminal history record information, the subject of a non-disclosure order, right, issued under this section, is not required in any application for employment, information, or licensing to the state that the person has been the subject of a criminal proceeding relating to the information that is the subject of the order. So in layman's terms, right, that information cannot be used or disclosed, right, in that you've had a criminal proceeding brought against you, right, when we're talking about releasing that information.
But if for some reason you do something criminal, they can pull it all out.
But that doesn't say anything about the arrest. You see, it says criminal proceeding. Does that include arrest? Right? I think some of the safer, I always tell my clients that the safest way to look at this thing is that if you're asking on an employment application, have you been arrested? Right? You need to say you've been arrested. Then it says, have you been convicted of any subsequent offenses? You can say no. Okay, as far as the conviction is concerned, because one, you got a deferred adjudication if you're asking for your records to be sealed. But if it's been sealed, okay, you can deny the fact of the criminal proceeding. Okay, and that's what it says. And so, right, the charging aspect, the charge brought before you, right, I think would be the initiation of the criminal proceeding. I don't think that that's going to include the arrest. Okay, so I think you can deny the effect of the charge and the subsequent proceedings after that fact. Okay, but it doesn't include, it doesn't say that they can't be used, maintained, or any other way for any other purposes. It still exists, but you get to claim that proceeding never happened.
This is very good information.
But there's all kinds of exceptions, and you can go on and keep reading in that section, and it's going to say that. And I've got some of them here.
I'd like to put the cart before the horse just for one question. Just so, don't go into depth. Just say whether it's possible or not. Can you pay to get a pardon or an expunction? And let me clarify my question. A lot of the times, if you get a ticket, they don't care about the fence. They just want money. They say, you come pay cash, we'll drop it down a little bit. Do they say, okay, it wasn't a heinous crime. You pay me enough money and we'll give you an expunction or we'll give you a pardon. It'll just take time and money. Real quick answer, yes or no?
Again, I haven't done any other pardons since the last time we got on the show. What I said was that I've helped 2 people, right, apply for those. One got it, one didn't, but I didn't do the whole process myself, right? You should get an attorney that specializes in post-punishment type of issues. Like, they have people that specialize in getting your record sealed, doing expunctions. I can do that. But as far as pardons are concerned, they're very rare, right? You need somebody that is really involved in the system, knows people.
That's what I mean.
Right, knows exactly how to go about doing the pardon aspect, because they're rare.
Because there's some people, they're rare because people think it's impossible to do it. You've got.
It's not impossible. It's definitely not impossible.
Yeah,
When you don't have to like actually know the governor,
Exactly.
right, for him to give you one, but you do have to present it in such a way, right?
Look, let's give you an example. Give you an example. A young buck here does something really stupid and gets convicted of a crime. Good kid, smart kid, wants to go into academy, but you can't do it. You're like, what did I do? What did I do? It was a stupid mistake. He's going to become, or she's going to become, a great product of society. But they got this tarnish on their record. So if they knew that it takes time, money, and effort, and they can get clean, they do it. But people think I'm doomed. I can't do it. I've got a friend of mine, and those are almost the same words. He goes, I was stupid. I made a stupid mistake. It just totally wrecks my life. I want to do this. I said, listen, you need to listen to the show, because I got an attorney coming on. He's going to be talking about it. He may shed some insight or direction as to what to do.
And so I'll give you an example. For sealing purposes, right, there's going to be a ton of exceptions. You can go in there and you say, oh, this is good, so they can't release my information relating to criminal proceedings. And then you're going to go to the next section, and it's going to, right, give a list of what they can release it for. And you're going to see on there that pretty much anytime you need a license, right, they're going to release that information. Okay? And anytime that it relates to something medical, something guardianship wise, something banking related, if you're right in the employment context, right, that stuff's going to be able to be released. So does a petition for non-disclosure, having that stuff sealed, deferred adjudication, does that really help you, right, when we're talking about those? And I'm telling you that I've done enough healthcare cases when you have a family violence issue that pretty much if there's any finding of family violence at all whatsoever, it really doesn't matter. And the sealing statute is very specific in that it says that you can't get it sealed if there's been, right, a finding, any offense that would fall under family violence, or an affirmative finding by the court that there's been family violence involved. And so any one of those aspects, if you have one of those findings, you're going to have an extremely difficult, right, road ahead of you in trying to get a job or keep your job at a healthcare facility. And I don't like it. I've had some cases I thought were dumb, extremely dumb. And for some reason we worked out a case. We worked something out because the costs and in other words, it was, you can beat the rat, but you can't beat the ride kind of thing. And so my client was like, well, look, this is going to cost way too much money. It's going to be way too much time and effort. I'm going to have to throw people under the bus. Like, I'm going to be thrown under the bus. I didn't do this, but it's going to be a whole lot easier just to take this Class C. Okay, but then they find out later, and I tell them, hey, look, this has, you need to go check with the healthcare facility, because I'm telling you, if you take this, it's going to be dangerous. They're going to have a right to do it. No, it'll be okay. HR tells me this, HR tells me that. And I say, well, look, I'm telling you that I've done enough of these cases. And sure enough, right, they go ahead and take this deal, and then, 2 weeks later, they're fired. And so
fight for your right, man.
And
don't give up. And
so and then you come to me and you're upset. And I said, hey, look, I tried to tell you this was going to happen, and you needed to make sure that you were going to be able to keep your job before, right? Anything like this, right? You took any kind of deal like this, and so you need to be extremely careful if you're charged with anything that could fall under one of these provisions. And then even coming back and getting a sealing order is not going to help you in the context of a healthcare facility employment, because, right, they fall under the exceptions of the sealing.
What about LTC?
Right, that's a licensing, right? But like we said, for purposes of that section, a conviction does not include any offense that was sealed. Okay, and so I don't know how that's going to relate to, since the DWI provisions. The DWI provision says if you've had any 2 convictions in the last 10 years, right, then you're classified as a chemically dependent person.
I was told by an instructor for license to carry when I was going through the course and the updates. There's the law, and if you look in the video, you'll see me doing hand motions. There's the law, but then LTC is its own little sphere of law. What may be okay over here with some type of conviction totally screws you over here, like you were just mentioning. So each one of these things that are regulated, I guess, have their own little tweaks and twists. So you got to pay attention to what those are as this applies.
Right, and a lot of times, generally speaking, a conviction, a deferred adjudication, getting a deferred adjudication, and then completing your community supervision and like we said, deferred adjudication is essentially what that phrase means. You're deferring adjudication. You're deferring judgment. Okay, so you're not having a judgment of guilty, and conviction and convicting the person, although you might find them guilty. You're deferring judgment in the case, an actual conviction, for a later date, and putting the person on community supervision. If they complete community supervision, it'll be dismissed. And so technically, if you completed community supervision on a deferred adjudication, you do not have a conviction. Okay, but if you get probation, you are essentially convicted and sentenced to jail, and your jail sentence is probated, i.e. suspended, okay, to allow you to stay out of jail and be out of jail and complete the terms of community supervision. And if you complete community supervision, then you don't go to jail. Does that make sense? You don't get your suspension from jail time revoked.
I remember Rick was talking one time with me, and I made some kind of comments about the harshness of things, and he said it very clearly and very plainly. And I agree with what he said, that the law is set up in incremental stages. First timer, depending on what the offense is, you do this or that, probation, deferred adjudication, do it again, and you spend a little time, more time, blah, blah, blah. And what you're saying here just reminds me of that. It's a progressive thing, and the law is trying to say, get your act together, get it straight, and there are provisions, but you got to do your effort on your side too to get it done, right? And
so a big part of this is that maybe if you listen to me when we first started this show, I told you, maybe, I don't remember, I'm assuming going way back when we first started doing this show, if you'd have asked me about deferred adjudication and non-disclosure and expunction about a DWI conviction, I told you you can't get an expunction or a non-disclosure for a DWI. You still can't get an expunction, but the legislature, made it available, since that time, for you to get, an order to seal your records related to a DWI. You can, if you get a DWI and you're a first-time DWI offender, and you want to get an application for non-disclosure, a petition for non-disclosure, you can do that if you had an order for an interlock device during the course of your probation.
What's that?
An order for an interlock device is one of those things you got to blow into to get it to start. Okay? And as possible, you can still get it without the interlock device, but you have a 2-year waiting period and a 5-year waiting period. So if you do the interlock device, you can apply for a non-disclosure to get your record sealed, after 2 years. If you don't have the interlock device, but you successfully complete probation otherwise, you're going to have to wait 5 years. Okay? And so it's always a good idea now, I think, to go ahead and get the interlock device and do the probation period and go through that. And Milam County doesn't offer it. I don't know why Milam County doesn't offer it. I think we've talked about Bill Torrey a lot, but I think folks should take it up with Bill Torrey about why we're not doing what we call pretrial diversion for DWIs and other things. Yes, I've gotten him to do basically a real basic pretrial diversion on a couple of clients. It was extremely deserving. Okay, but we don't have that program here, and we need it. And it's for things like this that you talked about, these really dumb cases like this case that I just spoke about with the...
Well, it's not dumb. It's the person did a dumb thing.
Honestly, sometimes the persons that I'm talking about are what I think would be innocent of the charge. Okay, especially, and even if they're not innocent, maybe they did a dumb thing, but it's not a great case. Does that make sense? It's not a great case. It's really not just, even if they're technically guilty under technical standards of the law, the circumstances were extreme. They were not like they were, and plus the harshness, right, of the consequences are going to be, right, more than they would be in a general case. And the circumstances just call for some kind of use of a different device. And that's why I think we should have a pretrial diversion program here in Milam County. And the pretrial diversion program means essentially that you're not charged. You're not charged. You enter into an agreement with the state, and they can put you on community supervision, make you do essentially what's called a community supervision. They can make you do a whole bunch of things, community service, classes, right? They can even make you pay a certain amount of fines, right? And after you've completed that, right, the district attorney or, county attorney agrees to, hey, we're going to just dismiss our charge. We're not even going to file it, or if we've already filed something, we'll agree just to have that thing dismissed. So you never go in front of the judge. And so you never fall under deferred adjudication or probation, right? And so you never fall under any of these because it would be what we call a pretrial diversion. And you could essentially come and get your records expunged. You could get your records expunged because the expunction statute would allow you to do that. Okay? Because you've never been given deferred adjudication. Okay, you've never been on community supervision under what we call 42A, which is a deferred adjudication or probation statute. Okay, you've had to do conditions, right? You've had to do certain things that you've agreed with the state. Hey, I promise you that I'm going to do these things. I'll pick up trash. I'll help the church. I'll go to classes. I'll get you some kind of test. I'll get this stuff done for you, right? But you're agreeing not to place me on deferred so that I can come back and get an expunction. Okay, and so that's another way you maybe get a DWI, right, arrest or something to that effect expunged, but that would be if they did not go forward in the criminal proceeding. They essentially dismissed the entire proceeding.
Okay, we're talking DWI. How does that apply to any other type of...
It would be the same thing. You could do the same thing, but for DWI it's important because there's no way for you to get an expunction on a DWI or even any other charge for that matter, but the DWI and family violence type of circumstances, and two, you hear family violence, you say, why would we want people committing family violence? Look, man, you have two brothers that get into a little heated argument at Thanksgiving or something, and they're both great people, and it really wasn't anything but maybe an offensive touching.
Yeah, but the question is, who called that in?
Right, exactly.
And that's what irritates me.
And you got two people that's never otherwise had an issue, or maybe you got two young people, like 17 and 18 years old, and the 17-year-old is going to be able to get his expunged, right? Because he's never been in trouble again, but the 18-year-old is now stuck with a family violence charge, and it's just like...
I got a question for you, man. Whatever happened to, you got a problem with me? Let's go behind this building and we'll take it out, skin on skin, fist on fist. Whatever happened to those days, man?
It better just be you and that person.
But it can't. You got
with no cameras and no phones.
I know, that's what I'm getting at. Why does everybody get so hyped up about this? You got a bloody nose, but you got your emotion out. You're fighting over some chick or something. It's just normal stuff.
But the guy called me, and so he wanted to fight this guy. This guy wanted to fight him. They called me. It was a funny call, and he's like, what is the one way I could do this? And I say, you need to get a written form of consent. Because consent... You just got
yourself another business, buddy.
Hey, because consent under the law, right, is for an assault purposes, consent, right, is a defense, okay? And so you can consent, right, to the assaultive conduct. For instance, like football, if you're playing a game of football, you're consenting to the contact, correct? So it's the same thing. And so if you consent, the one thing you can't do, though, is you cannot consent, right, to the use of deadly force. Okay, so it better just be straight fisticuffs. You guys want to fight, you guys need to sign a piece of paper that says you each consent, right, and you know the risks, and you understand that doing so, right, may result in bodily injury, but otherwise you consent to.
So you put on some gloves, right?
Yeah, you put on some gloves, and hey, that's how we used to say it. We put on some boxing gloves and JUCO. Blend bucks. If you're listening, you guys know what I'm talking about. We used to put on the boxing gloves and just handle it.
I like the Pugil sticks. Like rifle butt to the head. Man.
And so, yeah.
Hey, what about those weekend marriage licenses? Is that the same thing? Good from Friday night till Sunday night. Or Monday morning.
It's kind of like what is it? The gray. Shades of Grey, or
50 Shades of
Grey. 50 Shades of Grey.
I know nothing about that.
So you guys gotta watch the movie. But you're gonna have a problem on non-disclosure, getting it sealed, if you fall under kidnapping, trafficking, sex offenses, assaults, right? Offenses against the family, which is essentially violations of like protective orders, things like that, not paying child support, disorderly conduct, even, right, which would include a DWI, public indecency, weapons, and organized crime. So if you fall into those, you're going to have a problem, and you cannot get your record sealed if you're convicted of, if you've got a deferred adjudication for murder, capital murder, trafficking, continuous trafficking, injury to a child or elderly person, abandoning or endangering a child, violation.
Well, I hate to keep cutting you off, but you talk and you spur my brain full of ideas here. Would it be helpful for you, business-wise, and for the people out there who fall into this category, if they were to go to yours or Rick's websites and there's a list there, hey, real simple, plain and simple, because I'm as simple, as basic guy as you can get, and I need it simple. You had a felony, you have a misdemeanor, wanting expunge or a pardon, this is what you can do if you got this, forget it if you got this. Call me and you add it all up. If you have this, call me. If not, call somebody else, okay?
You're getting issues with the state bar and ethics and stuff like that and advertising, which I'm going to avoid at this point.
Can I do that? And I get a referral fee?
No, absolutely not.
No,
It'd be
okay.
that'd be probably
I'm half kidding.
absolutely. I would say absolutely unethical, but I would say at least probably unethical. But
But that'd be very helpful. A lot of people would just love that.
yeah. You can put that on your website. But the reason I don't like doing it is because they change it, right? And there's other ways to go about doing it. It's kind of complicated as well. I would say just call a knowledgeable attorney, right? Tell them your circumstances.
So if I put something, I'm just saying this because I know there's a lot of people who are really gnashing their teeth from stupid mistakes. If I go, look, there is a chance for pardon or expunction. Is that how you say it? Expunction?
Yeah, yes,
Okay.
expunction.
But you got to have certain things in your favor. Call an attorney. There is a possibility you can do it with time, effort, and money if you fall under certain categories. Don't just think that's it, your life's over.
And we've talked about the interest of justice orders for a probation when you actually have a conviction that have the effect of restoring your rights. You can get those, right? That's more in depth. If you got a question about that, email me. I can either answer the question or I'll refer you to somebody who does that all the time. All right, and there is a way to do that. And even if you can't get that order and it's too late, you've already been discharged from your probation and you can't come back and get that order, there is a way to restore some of your rights, and you can file it for restoration of rights.
What about pardon, man? It doesn't matter what you've got. A governor can pardon you. There's got to be a road.
No, there is.
Whether or not they say, screw it, I'm not going to do it, or okay, I'll do it. But at least there's some procedure that goes straight up to the top.
And that's what I'm saying. And so the number, but when you look at the numbers versus what's granted, I think an adequate explanation of your likelihood would be rare.
And I think that's because of lack of knowledge. I think people don't realize that they can do something.
Well, I'm saying based on the number that are filed, based on those that are granted,
I know where you're coming
it's
from.
rare. So I'm telling you that don't get somebody just that knows what to do. Get somebody that does that on an everyday kind of basis, and can really present your application for a pardon, right, in such a way that it's going to be really looked at, because you can get it done, and you don't have to know the governor just to get it done. Right. It's like you said, those times when it's unjust, and the benefit of society, the state, the families, and employers are going to benefit from getting this pardon. Right, a lot of times it'll be granted.
Yeah, I'm talking legit screw-ups, okay? I'm not talking heinous people, repeat offenders. I'm talking a stupid time. There should be some hope for somebody to get themselves clean,
Right.
Now, Ross, short on time here. Unless you got something else you want to wrap up with, I want to talk about next week with you.
I did want to say, let me see here. So if you're talking about rights, just know that you can get the pardon, the deferred adjudication, get the sealing order, you can get the expunction, you can get the dismissal and discharge, or the interest of justice order done for rights. For records, right, for all records to be taken away, you're going to have to get either not have a conviction or get an acquittal, get a pretrial diversion.
Can you give me a good definition of acquittal? I have an idea, but
acquittal is a not guilty verdict, or you go up on appeal and you maybe got found guilty, but then you go up on appeal and the Court of Appeals or Court of Criminal Appeals says, the jury was wrong.
Okay,
we're going to actually reverse and render a judgment of not guilty.
Okay, gotcha.
Okay, and so you're acquitted on appeal, or maybe it was a Fourth Amendment issue, right? And they find on appeal, they reverse it, and the case is dismissed, that's going to be maybe a more arguable thing. But if you're found not guilty, right, that's going to allow you to get the expunction. If you are pardoned, there's a process for, if you get a pardon, to come back and get your records expunged. Right? Don't ask me specifics about that, right? Because I don't do the pardon, so I've never done the expunction.
See, my mental thought process would be your pardon, it automatically does that.
Okay, and so that's going to say all records. There's not any records, even of arrest, after that point. But you can get some records, right, sealed, right? If you've got a deferred adjudication, right, and you get, right, some kind of petition for non-disclosure, order for non-disclosure of those records, but you're still going to have to admit to maybe the arrest, and you're still going to have some of those records existing. So there's rights, and then there's records. And the only two ways that you can get any records, right, put aside is expunction and sealing. And if you want it totally done away with, you're going to have to get the expunction, which again, you're not going to be able to take deferred adjudication, right, with some kind of probation. If you get any kind of probation, whether it be after conviction or deferred adjudication,
that's why, ladies and gentlemen,
you cannot get an expunction.
You need to call attorneys who know what they're doing. Attorney Benton Ross Watson here is sharp. Rick Dodd, sharp as tact, man. These guys know what they're doing. Speaking of which, we can't thank Rick, Copley & Dodd, Krebs Law Firm enough for sponsoring the program, like so many of the other sponsors too. Now, Ross, we have to cut it short here. Let's talk about next week. Ladies and gentlemen, I've got a major seminar next Saturday. I will not be here. We are going to put the captain's chair, I guess we want to call it, right? We're going to the con, and we're going to give it to Ross here. He's going to do a great job. You know, you did it last time, and everybody loved it. Who got any ideas what you're going to do?
No, we'll just have to stay tuned. We'll have some surprises here, man.
Okay. Well, maybe I'll pop a phone call in or two when I got a break and see what's going on. But ladies and gentlemen, Ross will be running the show next Saturday, the entire show, and I'm sure it's going to be fantastic. And I'm going to ask, please, to support him 110%. Call up, interact. And I'm telling you, everybody, if you're not paying attention or calling in to these attorneys, you're crazy. I know you know somebody who needs some help, or there's something when it comes to trusts or whatever. These guys know what they're doing, so give them a call. So we want to thank again Copley & Dodd Krebs Law Firm for sponsoring this large segment of the program. Any last words there, Ross, till next week?
No.
All right. Then
let's
tell them how to get a hold of you.
Okay, so 105 East Main Street's my office here in Cameron. You can come by and see me, or you can call in for an appointment, Houston, College Station, or Cameron even. That's 254-605-4140. That's 254-605-4140. Right, make sure you leave us a message. Also, we do get emails. That's for some reasons why we talked about the expunction and sealing topics today. But if you do email me, make sure you leave your phone number, because sometimes I can't always get back to you in email. I like to call you. Just make sure you email me at benton@watson.legal. That's benton@watson.legal.
Sounds great. Ross, thanks. Appreciate it. Joel, let's take a